Okay, good afternoon, everyone, and welcome to today's Brexit Clinic. My name is Henrietta Brealey. I'm the Director of Policy and Strategic Relationships at the Greater Birmingham Chambers of Commerce, and I'm joined here today by our fantastic guest experts, Andy Ilsley, who's a VAT Director at Chamber Patron RSM, Annabelle Mace, who leads the UK Business Immigration Practice, Chamber Patron Squire Patton Boggs, and is a partner in the Labour and Employment team, and David Reeder, who is Director of DKR Trade, Training and Support. Now, I'm going to give you a quick bit of introduction to the Chamber and today's event before I hand over to them to really do the heavy lifting today of giving you a bit of advice and guidance on the latest developments, Brexit, and what they mean for your businesses. So, by way of introduction, some of you will be very familiar with this. This is a Chamber member-only event, and a number of you have been to previous Brexit clinics. But for those of you who aren't, the Greater Birmingham Chambers of Commerce is a not-for-profit business membership and business support organisation that exists to connect, support and grow local businesses. As a fun fact for you, we were founded in 1813, and one of the key reasons for which we were founded was to help local businesses with access to the European markets in the wake of the Napoleonic Wars. So it's funny how times and contexts change significantly, but some issues do seem to come up in new forms. Crucially for today, as part of the Chamber, we have a significant international business hub, with colleagues offering advice and guidance on international trade training, and export documentation support and services. So when it comes to Brexit, bit of introduction, what is going on? Well, this won't come as a surprise to any of you. As you'll all know, a deal was agreed on Christmas Eve between the UK and EU for implementation on New Year's Day. A lot of businesses, of course, during that time either had limited staff in or were on complete shutdowns as a result of the festive period and bank holidays. So it's really only been the first couple of weeks of January that businesses have, in lots of cases, have really started to get to grips with what the detail is for the Brexit deal and what it means for them. And of course, the central issue that is emerging is that what the deal is a trade deal. So there's some really significant elements to it. Tariff-free trade for goods, where rules of origin are met. That is really significant in a trade deal. But what it is not is access to EU institutions, membership of the EU, customs union, single markets, VAT mechanisms, etc. So there are significant changes for businesses, and we are hearing from growing numbers who are concerned about the significant increase in bureaucracy, administration, challenges getting goods in and out of the country, and so on and so forth. So we're continuing to listen to our members, find out those areas where perhaps it's teething problems, areas where we can support businesses in getting up to speed, developing their skills, but also those areas where fundamental change is going to be needed. We can pick them up in our lobbying efforts, both directly ourselves and through the British Chambers of Commerce. Because as we know, while the Brexit deal may now be done, actually negotiations between the UK and EU are going to be continuing over the years. So we'll be continuing to do our utmost to escalate those issues there. When it comes to the support available from the Chamber, there are a number of international trade training courses that I wanted to raise awareness of coming up over the coming days. We've got a beginner's practical guide to exporting, introduction to authorised economic operator, understanding exporting and export documentation as the next three. And those are really for people in your business who need to get that more fundamental understanding of how this all works. So you've got those in-house skills and knowledge moving forwards. Brexit checklists, we've got a number of free resources up and available on our website as part of the West Midlands Combined Authority supported project. And they basically summarise what's changed, why, where to go for more information across a number of different key areas: importing goods, exporting goods, delivering services, transferring data, and more. We're continuing to offer free customs support, so for businesses who just want a bit of clarity on what they should be doing around documentation, where to get key information, etc. Our export documentation team are fielding a significant number of calls at the moment, supporting businesses in those areas. And then finally, I mentioned lobbying support. At the moment, we're particularly looking here from businesses who are happy to share a case study. Could be anonymous, could be named, but businesses who are coming up against issues or finding opportunities, who would be happy to share their experiences, because it really does help convey to stakeholders what's really going on in a way that just sort of quoting data and numbers can't do. So please do get in touch with us on kbm@birmingham-chamber.com. KBM stands for Keep Business Moving, part of our wider campaign around supporting businesses through COVID-19 and Brexit. And we'll be very keen to hear from you there. Right, well, that's more than enough from me. I'll just finish on a quick summary of what today is going to look like. I'm shortly going to hand over to our guest experts for some quick fire presentations, just 5 minutes each, highlighting those key areas based on their expertise, the areas of knowledge that they think businesses should be aware of in relation to Brexit. Please do listen in, think of what this could potentially mean for your business, come up with some questions, reflections, thoughts, because we'll then be moving into our breakout discussions. You'll be split into one of 3 groups. It's nice and simple, little pop-up will appear, just click OK. And you'll be put into a breakout room and a different guest expert will be dropped in every 20 minutes to answer questions directly relevant to your business. As always, please do treat anything you hear in the breakout discussions as confidential. We want to make sure that everyone feels able to share any questions they may have or concerns relating to their business. Once you've had a chance to speak to each guest expert, we'll reconvene back in the main room to do a quick bit of wrap up and close promptly at 2:30 p.m. In each breakout room, there'll be a member of Chamber staff. It'll either be myself or my colleagues Emily and Dan, who some of you will meet shortly, who'll be on hand just to sort of keep the conversation moving and also feedback at the end of it to sort of summarise the issues that we're hearing from members. So we can pick that up in future activity, spot any areas where perhaps more support would be useful in future. And if you have any technical difficulties at any point during today, there should be at the bottom of your Zoom screen a little something to put your hand up, a digital hand up. If you do that when you're in this main room or in the breakout rooms, my colleague Grace will be on hand to answer any questions, sort any technical difficulties, and make sure you're back online in no time. Right, that's more than enough from me now. I'm now going to hand over to Andy.
Yeah, good afternoon, and thanks everyone. I've been asked to share a few insights into the impact of Brexit, particularly as it impacts on the service sector. It's fair to say that Brexit has taken up quite a lot of my waking hours in the last few months, and a few of my sleeping ones as well, if the truth be known. And we knew that VAT and indirect taxes, which is my particular specialism, would be the biggest impact. But principally, as Henrietta mentioned, the deal that was struck between the UK and the EU just before Christmas is around the movement of goods and how that impacts on supply chains and some very practical kind of issues coming to the fore on that. Very little, and in fact there's been quite a lot of concern that the agreement is very light on the impact on the services sector. And in fact, in the sort of closing days of the deal, as they were trying to put the deal to bed before the end of the year, there was a lot more interest on the impact on the fishing sector, which is a tiny part of the UK economy, of course, no less important to those who are involved in it. But it did seem that the importance of the service sector was kind of being a little underplayed. So, just to illustrate the importance of the service sector to the UK economy, really it sort of picks up the numbers in this quite busy slide. So the UK operates a massive trade surplus in services. In 2019, had a 12.4 billion surplus with the EU, 10.6 billion with the US, and 31.86 billion with the rest of the world. And what it represents is a broad church of different services. The service sector employs 2.7 million in the UK, as a percentage of UK GDP, 7.75%, and that's spread across 600,000 businesses, which is actually an average staff of 4. When you think that covers the the whole range of professional service organisations to the to the small businesses, and we've seen the challenge in the sector generally because of COVID, particularly across the leisure and hospitality sector. But it does indicate just how important that is to the UK economy. The main issues for the service sector then are principally how easy is it going to be for UK service providers to operate in the EU now, as we are now in this fully into this post-Brexit period. And as I say, the deal itself doesn't talk a lot about actually how services will be provided. So the four founding principles of the EU, which were actually sort of sacrosanct and keen to be maintained, around the free movement of goods and services, the free movement of people, the freedom of establishment, free movement of capital. And businesses in the European Economic Area, which includes the EU plus Switzerland and Norway, can take advantage of passporting that allows them to carry out their business in another EEA member state without further authorization. And there's limited information on how that will work in the agreement. Well, how does it specifically affect VAT, which, as I say, is my area of specialism? Well, in broad terms, not significantly. The place of supply rules, which are important in VAT legislation to determine where a service takes place for VAT purposes and therefore where they're taxed, hasn't changed fundamentally. So the business-to-business rules that say if you're providing services to a business in an overseas territory, be that in the EU or beyond the EU, that is not subject to UK VAT, it's subject to VAT where the customer belongs, and they apply an account for that by way of a reverse charge. So in itself, it doesn't change the issues around needing to consider whether or not you need to register. There are some niche implications in certain sectors, for example, in financial services. So now, if you are providing financial services to UK customers, that is exempt from VAT under the VAT exemptions in the UK, and you can't recover VAT against those supplies. Previously, up to before the 1st of January, if you were providing those services to a customer outside of the EU, then you could recover the VAT. That's now been modified to include any business, any customer outside of the UK. So massively improving the VAT recovery of people who are providing financial services to EU customers, and that's that is going to generate a significant boost to financial services sector. Where you're supplying VAT services to customers in EU member states, just be aware there are some rules which are still the same post-Brexit as they were prior to Brexit. So if you were providing services, for example, that relate to land, you're an architect or a construction business, then you need to consider whether or not you need to register for VAT in those countries. And because the UK is now a third country, many EU member states are requiring fiscal representation, a formal someone to act for them formally who takes on joint and several liability for VAT, and that's going to increase the costs of compliance for UK businesses. That's broadly the key messages as affect services. I'm aware that many of the post-Brexit practicalities are around the movement of goods. I know that David will speak to some of those, and I'm certainly around in the breakout sessions to deal with any queries on those.
Fantastic, thank you, Andy. Certainly a complex area, and I know many businesses attending are a mix of people who are trading in goods, but also services for their clients as well, and a number of services firms as well. So I'm sure you'll have plenty of questions in the breakout discussion. Annabelle, over to you on business immigration.
Thank you, Henrietta. So I am a partner at the law firm Squire Patton Boggs. I'm in the Labour and Employment team and head up the business immigration team. And so since the referendum, I've been preoccupied with all things people related, and particularly in relation to their ability to work, both EU citizens in the UK and British citizens in the EU. So if you can just move me to the next slide. Thank you. So I preface this briefly in terms of the hot topics for today are not the plight of UK citizens who are already resident in the EU on or before the 31st of December, and EU citizens who are resident in the UK by that date, because they are already protected in terms of residence and work rights to work by the withdrawal agreement that we signed up to at the end of January 2020. So the concerns about work permits and business travel and so on all affect those people who were not already, so Brits that were not already in the EU and EU citizens who are not already resident in the UK. It's all about the position of those people who will be travelling for work or business from the 1st of January. And as we know, we've talked about for a long time, pre-movement came to an end on that date. And so it effectively means, if you're thinking about British citizens, that we are now being treated as what were referred to as third country nationals. We're not members of the EU. It sounds obvious, but with that comes the position that we are treated as any other non-EU country when it comes to the ability to work in the EU. So a kind of helpful way of looking at it is if you're a business sending a US citizen into the EU, you would be looking at treating British citizens in exactly the same way. Now, the trade agreement that was entered into at the end of December does include a very limited framework for business mobility, but to cut to the chase, it really doesn't give that much comfort. It's not that it's a trade agreement. It's not an agreement that was sort of specifically intended to deal with the immigration aspects of people in and out of the UK, apart from ending free movement. But it doesn't provide much comfort, I'm afraid. What, as a business, UK business sending staff into the EU, what you will now be looking at is, and this is one of the biggest challenges, what are the existing immigration rules for sending workers into the EU on a country by country basis? The Trade and Cooperation Agreement does provide a list of permitted business activities, but that we're still dependent on seeing how each country implements those provisions. In some cases, the EU country may already have more generous provisions than those provided under the Trade and Cooperation Agreement. And in some cases, when it comes to implementation, they will be able, to implement sort of more onerous paperwork and administrative details. So the biggest challenge, just moving on to the next slide, is that businesses will be sort of having to look at, rather than thinking, well, what are the EU rules in relation to immigration? It will be a question of checking national legislation on a country by country basis to see what the list of permitted business activities are. From a very practical perspective, if you're looking at sending somebody on a business trip to the UK, in comparison to the situation before the end of December, their visits will be limited to 90 days in any 180-day period. And that's not in each country, that's throughout the whole of the Schengen area. So it's important, if you've got people that are going to be travelling regularly into different countries, that they actually track and keep an eye on the number of days that they're going to be spending in Europe, so as not to exceed that. Generally, if it's known that you're going to be exceeding that time limit, you would be required to get a work visa for each day, for each country that you're going to be traveling and working in. And I'll talk about the sort of permitted business activities in a minute, but the rule of thumb will be, if you're intending to visit a country, an EU country as a visitor, to do certain business activities, unless that business activity is specifically permitted in that country, then that will trigger the need to get some sort of work permit according to the rules of that country. And on the next slide, there is a list, for what it's worth, of these permitted, if you could just click me through to that next slide, a list of what these sort of very, very scant permitted activities that were given under the TCA. So, as you'd expect to see, visitors are allowed to carry out meetings, They can attend training. This is really the starting point, the absolute minimum that countries will be required to allow visitors to do. But in most cases, they may go further than that, or they may provide more detail. Certainly for EU citizens coming into the UK provisions are more generous than that and go into more detail and are more helpful as a guide in terms of what workers are permitted to do. So for the time being, that's what's there, but this is of actually limited use. And as I keep saying, you'll need to go to the individual country and see what their specific rules are. On the next slide, I've just set out the additional sort of limited provisions that the TCA talks about. So there is an exemption for business if you're going into the EU for sort of business travel for investment purposes. But that's something that you'd perhaps expect to see under the list of permitted business activities anyway. So that's not sort of particularly big news. The TCA also refers to contractual service providers, independent professionals and intra-company transferees. It provided some sort of limited guidance on the fact that EU countries will not be able to impose quotas for those categories, but it doesn't provide work permit exemptions. So the fact that you may have a sort of group entity in a European country is not going to get around the need to obtain a work permit if that person's going to be doing more than their permitted business activities as specified by the country in question. There is talk of, it's possible that over time there will be bilateral agreements between individual EU member states and the UK allowing for preferential business visa rules of some description or another. And so over time, that may become more helpful. In Germany, for example, my contact there has explained that the UK has been treated as a friend. A sort of a friendly country with specified sort of preferential treatment, and that may sort of spread throughout the EU over time, but it's not going to happen immediately. So we're just going to have to sit tight and see whether the rules become more favourable to the UK or not. And so that brings me to the end of my section, and I look forward to taking further questions in the breakout sessions.
Fantastic, thank you, Annabelle. And now last but by no means least, as I know a number of you are very interested in understanding more about implications on goods, I'm going to hand over to you, David.
Okay, thank you, Henrietta. So David Reader. So I've been asked just to introduce this topic about moving goods between the UK and the EU. And what I thought I would do, there's no slides from me, so you're not missing anything if you're looking for those, but I would just highlight what I have decided are the four biggest issues that businesses seem to be wrestling with as they adapt to the new relationship that the UK now has with the EU. And as I've been moving amongst businesses since last year and certainly into the early part of this year, these four issues are the ones that businesses seem to want to talk about the most. So I thought I'd flag those by way of sort of an introduction to this topic, and they may resonate with a number of you. So the first thing is, as we know, pre the end of last year, customs union, so goods moved readily between the UK and the EU. But effective from the 1st of January this year, there is now a requirement to do customs declarations. So whether you're exporting to or importing from the EU, there is a need for you to do a customs declaration. But in the same way, there is a need for your EU partner to do their own customs declaration. So in simple arithmetical terms, for every transaction, there are 2 customs declarations. There will always be an export declaration, and there will always be an import declaration. And how you decide who does what is driven, as you will know, by the Incoterm. And the Incoterms and the rules governing who can actually lodge customs declaration has brought the need to think about Incoterms probably into sharp focus, and in particular the 2 Incoterms that sit on the outer edges of Incoterms: ex works, where your customer collects from you, or delivered duty paid, where you effectively do everything to drop those goods at the door of your customer. And there's been a move in the last few months, certainly during 2020 and probably before that, certainly amongst European buyers, to look to move towards a DDP requirement when goods are being delivered. All well and good, they've got their reasons for that, which we might discuss in the breakout rooms. But actually, in order to do that import declaration when your goods arrive in the EU, the declarant has to be registered in the EU to do it. So if you're a UK business, it automatically means that if you're going to do that import declaration, which under the Incoterm you would be obliged to do, you would need to be registered in the EU and accountable for any EU VAT on that import. The same works in reverse on ex works. Second aspect, which links very closely to customs declarations, is safety and security declarations. And this is really an underpinning of the world in which we live becoming a more insecure place. But it is a requirement that with every import and every export, there is a safety and security declaration lodged. And again, there's a requirement to lodge one when goods leave the country. There's an equal requirement to lodge one to allow goods to enter the country. And that works in both directions. And the responsibility for the safety and security declaration sits with the carrier of the goods. So given that the vast majority of goods are likely to be travelling to Europe by road or truck transport, then simplistically, it will be the responsibility of the carrier, the haulage company, the truck company, to actually lodge that safety and security declaration. And this is, I think, leading to some concerns. I was talking to a business the other day that had experienced a problem because there had been a delay somewhere in the chain. They weren't sure which. I don't think the information had been shared with them completely accurately, but my guess is that it was because whichever haulage company was responsible had probably not arranged to get permission from the EU for those goods to arrive in the EU, something that needs to be done prior to the goods leaving the dispatching country. Third, rules of origin. This is something that effectively fell out the side of the deal. The deal was heralded as free trade, greeted generally, I think, by business with some relief because of the fear of what a no deal might have meant. But in there was the rules of origin, which in very simple terms means unless you can demonstrate and prove your goods are of UK and or EU origin, then duty may still be payable on those goods as they enter the importing country. And I know this is exercising the minds of businesses, particularly those whose business revolves around the supply of goods, where for whatever reason they are not able, or they're concerned they may not be able to prove UK origin. Again, perhaps that's something that will come out in the breakout groups. And lastly, on my list, the Northern Ireland Protocol, something that I know is affecting businesses trading with Northern Ireland from an exporting or a selling perspective. Doesn't matter if you're buying from Northern Ireland because the rules haven't changed, but certainly selling to Northern Ireland has now become as if you were selling into the main body of the EU. And the reasons for this are because the land border that exists between Northern Ireland and Southern Ireland would be the obvious place perhaps to put some sort of customs point between the UK and the EU, but for all sorts of reasons it was decided that wouldn't be the best place, and so in very simple terms it was decided it would be the Irish Sea, which means goods passing into Northern Ireland, even if they're planned to stay in Northern Ireland, do require customs declarations. So I hope that sets the scene. I'll look forward to the breakout rooms. If you have other issues, then please feel free to raise them, but it's back to you, Henrietta.
Fantastic, thank you, David, and thank you for managing to rocket through those particularly complicated areas very concisely and very clearly.